Donna Adelson has filed a motion for new trial. I read it, so you don't have to. Let's get into it. It's 18 pages long. I'm going to try to get it all done in one video. She's filing it under 4 grounds. It's juror misconduct. Verdict is contrary to the law or weight of the evidence. The court erred in a decision of a matter of law which arose during the trial. Probably, but I don't know if it's reversible. And for the other cause not due to Miss Adelson's fault, she did not receive a fair and impartial trial. The judge was unfair. Not only that, the supporters of the state in the gallery were laughing and making a spectacle of themselves during the trial, which was distracting to the jury. The judge also rushed them when it came time to Donna deciding whether or not she was going to testify. And that's problematic because they had asked for 4 days to present their case, their defense, and it was day 2 of their case. So there was no reason why the judge needed to rush that. He should have given her the night to think about it. But anyway, we'll get into it. So on top of this, and probably to develop their juror misconduct issue, they're also asking for leave of court to interview jurors number 7 and number 5. Number 7 was the foreperson, the one who went viral on TikTok. They allege in here that she violated one of the rules because on August 26th, and this is what they say in the motion, she posted on social media that she was selected as a juror. They don't say whether or not she said she was selected as a juror on this particular case, just that she was selected as a juror, and likely they would like to interview her to develop whether or not she knew anything about the case ahead of time, and that's why she felt the need to announce it on her social media, and whether people solicited her in her comments or in direct messages to vote a certain way. Maybe they sent her video. They didn't say all of this, but that's obviously the basis for which they want to interview her. She's taken the video down, apparently, the August 26th video, but the defense has a copy on a jump drive that they will be providing to the judge. I mean, that better be the basis, because if it's just that she announced that she was picked as a juror, I fear that's not enough, because they specifically cite to the jury instruction once they were chosen, saying you're not permitted to communicate about this case with anyone about this case. It also goes on to say you can't post on social media about the case. Saying I was picked as a juror, I don't think is necessarily talking about the case. If I'm the defense attorney, I want to know, why did you feel the need to post that? Was this an exciting thing for you? Did you really want to get chosen? Because that's problematic. And I'd want to know if anyone sent her anything, if she looked up anything. They also want to get rid of, or they want to talk to juror number 5, because apparently he went on a podcast and he said that he definitely noticed Donna Adelson's behaviors and reactions. But then he goes on to say that he, quote, obviously did not take that into deliberations. He's human. Of course he's going to notice her attitude, her behavior, her facial expressions. Every defense attorney tells their client that you are on stage. They're judging you. They're judging the way you talk to me. They're judging the way I talk to you. They're reading body language. It's human nature. It's the reason why you have to file a motion to get your client in regular street clothes rather than their jail garb, because everything matters optically. So I don't really know that goes anywhere, because he saved himself when he said that he obviously did not take that into deliberation. On to the first degree murder, them saying that the weight of the evidence did not support the verdict. Before I get into this, I just want to say nothing I say here is an indictment on this motion, because I think it's a good motion. I would file the same motion. You have to. I think it's well written. I think it's decently reasoned. I just don't know that it's going to go anywhere, because it starts with, I think, faulty reasoning. So it starts with count 1, first degree murder. At this stage, the court must make a finding that Patricia Bird was credible before considering Mrs. Adelson's alleged confession. And then goes on to say, by the way, under no set of circumstances can Bird be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan was obviously not white. I don't know, was she, wasn't she? Was she white passing? I don't really remember. But that's not how it works. Just because one thing is not true, you don't throw away the person's entire testimony. It's the jury's job to weigh the credibility of all of the evidence, right? So they get to see everything and they get to judge whether or not that testimony was credible, right? They also go into the fact that these people were promised certain things, right? They are in the jail and maybe this one's sentence got cut in half and this one's going to try to go see her kid. But here's the thing. Their credibility is only in question. And that question is for the jury to answer. If they say, hey, okay, this person has an incentive to lie, but they get to take that further. But do I think she's lying? Do I think that she is in fact lying? Given all the other stuff that I learned throughout the course of this trial, is it likely that what this person testified to is true? Or do I think that she's lying? That's the jury's job. You don't get to say, I don't think that this person was credible, so she wasn't credible, and so everything else crumbles because now you don't have a confession. And that's basically the bulk of the rest of it. I mean, there's more, but they essentially pluck this out. This is out of play now, and so everything else is not sufficient, is not legally sufficient because you don't actually have an utterance that proves that she was in on it.
That's not how it works.
I mean, I would love for it to work that way as a defense attorney, but you don't get to just you don't get to do the jury's job and determine the credibility and then say, now that you don't have that, let me show you all this other case law I have that says that what you have left isn't sufficient. So without that, there is no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed. I don't know, man. I kind of remember that wire call after the bump where she calls Charlie and Charlie says, does it have to do with me or other people? And she chooses an option that's not on the table. She says, both of us. Is that someone who wasn't in on it? That's evidence. That's evidence that the jury gets to consider. And they get to consider that in light of the testimony of the jailhouse snitches saying that she confessed. And they go on here, although a person can be convicted as a principal to a criminal offense based on words alone, there must be competent, substantial evidence these words were spoken in advance of the crime. There's a lot of inferences that were made throughout the course of this trial because murder cases are oftentimes built on circumstantial evidence. I don't know, man. You and your son talk on the phone about 80 times a day. And it was done in that chain. It was in the train. It was you to Charlie, Charlie to Katie, Katie to one of the two guys, right? Like, and then reverse order, right? The jury's allowed to consider that. The jury's allowed to consider that that is an implication of there being a continuity of conversation. And again, they're considering it in light of the fact that they also have two people saying that she confessed, right? It's not everything, but it's one of the things, and the jury gets to weigh it. It's their job to weigh the evidence. What is strong, what is not strong? We don't know how they weighed the things individually either. Even if there is no evidence to establish the second element, that she did some act to assist the other person in actually committing the crime. Encouragement is an act. Talk to Katie, let me know what she says. They're imposing this impossible standard that there has to be a smoking gun, and there doesn't have to be a smoking gun. A smoking gun is just nice to have. And they call it like impermissible stacking of inferences, but it's not really. There are a lot of inferences that are made, but it's all in context. And it's, again, the jury's job to decide what's credible and what isn't. The primary evidence against Mrs. Adelson was the motive, perhaps in the opinion of the defense. But the fact finder is the one who ultimately determines whether or not the evidence was sufficient. I skipped a few pages because I have 40 seconds left, and we still have to get into the unfairness of the judge and the overall atmosphere in the courtroom. So let me know if you want me to make a part 2 to go into that and maybe go back more into the bulk of their argument. But they kind of say you might have enough for an accessory after the fact, but that's it. I'll leave you with this. I don't know. She seems like a delight to me. Oh wait, in summary, I don't think it gets granted. Not for those reasons anyway.